I know. I gave you all that.
You said what? Can you? Are you putting on the record why, or do you want me to put it on?
I would prefer you did.
Huh?
I would prefer you did.
Okay. That's fine. Are we ready?
Well, you know.
Showing your age.
We can move it. Is that? Kenyon Klein. That's her. All right. Are we ready?
Yes, sir, we are. Ms. Klein, you're gonna step up to me. Good morning, Judge.
Good morning. Good morning, Ms. Klein.
Good morning.
All right, so on Ms. Klein's case, for the record, and I believe that the state is going to be dismissing this case, but for the record, this court, there's a F1 felonious assault and a disorderly conduct. This court received a call from Internal Affairs stating that after review of the body camera, that there was a belief that the charges were inappropriately brought against Ms. Klein, and asked for Ms. Klein to be released last night, which this court did at about 12:45 a.m. And Ms. Klein is present today. How is the state proceeding?
Yes, Your Honor, we're going to dismiss in the interest of justice.
It appears that Ms. Klein has no record as an adult or juvenile. Does the state have any opposition to this being sealed, or I guess being sealed now while the state does?
Your Honor, I do not have a position on that.
Investigation. All right.
I would say if they're going to be investigating it, then it's probably best that it not be sealed or expunged at this point, so that they can continue investigating.
I am going to order that it be blocked from the clerk site at this time. And then I'm sure Ms. Medash or any other counsel of Ms. Klein's, once it works its way through, will ensure that this does not show up on her record. All right, thank you. Velasquez.
There is a request for a temporary order of protection. Good morning, Your Honor.
Good morning. Waive probable cause.
Yes, Your Honor.
You're Supreme Court certified? Okay, I don't need to see you. All right, as to bond.
Your Honor, as to bond, I am gonna ask for, Officer Spade's assistance with the temporary protection order. I am pulling out a copy of the order in Spanish for Mr. Velasquez. Spoken with him, he is in agreement with, executing this order, Your Honor, so he's going to be signing that. I would just ask for box 13 to be checked, I believe it is still box 13, Your Honor, so that he can return with a police escort to obtain personal items. Mr. Velasquez, and excuse me, I'll slow down a little bit. Thank you. Has no history and no failures to appear in the last 5 years. The complaint on this case does charge this as an M4, but it's charged under the E subsection, and it's an allegation of a DV threat, so I believe it should be, I'm sorry, it's charged as an M1. I believe it should be an M4, Your Honor, given the subsection it's charged under. Mr. Velasquez is gainfully employed. He works at Ruberger. Your Honor, he was arrested last night and was taken to the Justice Center without his wallet or his cell phone, so he would be unable to post a bond for himself. I'm asking for an OR considering his lack of history, the fact that this is an M4, and his inability to pay his own bond. And I have informed them, Your Honor, that he does need to, if he's going back to the house to get personal items, obtain a police escort before he goes to this address.
From the state.
Your Honor, it is, as counsel pointed out, should be charged as an M4, given the fact that it's a domestic violence threat, and there does not appear to be a history that would elevate it to an M1. However, these allegations are serious, as they allege the defendant climbed on top of the victim and threatened her with a knife. I do think an aggravated menacing charge could be charged in the alternative. Given the seriousness of the allegations, I do not think an OR bond is appropriate. I would ask for some monetary bond.
$5,000 anyway, plus jurors if requested.
Would you consider an alternate, Your Honor?
No. Saldana,
For a jury report, then,
There is not.
is it so? Okay.
There is a request
Okay.
for temporary order of protection.
Nick Guard for Mr. Saldana.
all right. Good
Please
morning.
not guilty. I think that prior to going into any mitigation, the prosecuting witness is present, and I think it would be consistent, I guess, just to hear from her.
Good morning, ma'am. What would you like to say?
Buenos días, señora. ¿Qué quiere usted decir? ¿Qué quiere decir?
Quiero quitarle los cargos.
I would like the charges removed.
She thought you were going to be asking her a question.
Ma'am, are you concerned for your safety or the safety of any children?
Señora, ¿usted teme por su vida o por la vida de cualquier hijo que usted tenga en común con él?
No.
No.
Are you denying this happened or you just do not want charges filed?
¿Usted niega que todo lo que se alegó que ocurrió es mentira o usted simplemente no quiere que tenga cargos?
Niego lo que pasó.
I'm denying what happened.
From the state?
Your Honor, I do think that the temporary protection order should be put in place, and I do think a monetary bond is appropriate regardless of what the victim has to say here today. The allegations are that the defendant caused physical harm by striking her in the head and body with close fists, leaving the victim with visible injuries on her wrist, right thigh, and neck. During the incident, the victim stated that she lost consciousness and she was transported to the hospital based on her injuries. The questionnaire that she filled out is very concerning, as she said that he has recently threatened to kill him or herself, has recently abused me while pregnant, as well as done other things in the past. When she filled this out, she had very much concerns regarding her safety. As she said, I believe that my partner will seriously harm and or kill my children or me. And does not feel safe to remain in her home. So I ask that the court issue the protection order over her objection and impose a monetary bond.
Mr. Saldana is also covered in bruises. This questionnaire is not the affirmative statements coming from the prosecuting witness. It's someone who likely is not a native Spanish speaker, probably talking to a telephone operator, asking whether or not she'd like to check particular boxes. She's here today, having denied the allegations when asked by a judge.
Do the parties have somewhere to stay separate,
They do.
period, while this is pending?
Mr. Saldana does. And it's-
The allegations are serious. The prosecuting witness is here today denying those. Mr. Saldana has no record, no failures to appear. The safety questionnaire is concerning, but to defense's point, on the top one, everything is checked and it conflicts with what I have in the pretrial services bond investigation, at least one of the boxes that are checked. I do think while this case is pending, the parties need to remain away from each other. So I am ordering the TPO for the parties to remain separate, but it will be an OR. Booker. RAC. This one you're ordering.
Booker, right on, Mr. Booker. Right after the officer.
Okay with you, Mr. Booker. First, Your Honor, we're gonna enter a not guilty plea for Mr. Booker.
All right.
What you have in front of you is an M4 trespass and an M4 menacing. Judge, I've spoken with him, he's not gonna have any issues staying away from either Coffee and Emporium or the employee who works there. That's
1 second. I have Nash. Can I have Booker? Sorry, thank you.
Yes, Your Honor. So he will be staying away from Coffee Emporium, the prosecuting witness on the menacing charges, an employee there, Your Honor. There is, I know that you're gonna see a pending trespass, that's from a different location that he had been ordered to stay away from and he had not gone back to. So we do know that he is able to follow court orders, Your Honor. He tells me that he's been staying with rest and getting services there, Judge. I did have our social worker, Christine Griffin, speak with him about what else our office could potentially offer Mr. Booker in terms of services. He's a graduate of Princeton High School. Your Honor, and so he's, local to the area, lifelong resident of Cincinnati. I do see some failures to appear, but I think we can get him a ride to court through the Hope Line judge. So, I'm asking him for him to go back to treatment rest, and I think an OR with a stay away would effectuate that while also ensuring community safety, since he has followed stay away orders from the court thus far.
From the state.
Allegations are that after being previously trespassed from this location, the defendant returned and remained after being asked to leave, and then told the employees at Coffee Emporium, "I'll beat your ass, you punk bitch." State's asking for some monetary bond, electronic monitoring. He's returning to a place he's not supposed to go.
Would note, Your Honor, I did look at these prior criminal trespasses. I did not see one from them.
All right.
Over to.
We just, oh, he was going out, we can go on.
Where is the rest location that Mr. Booker is at?
In Price Hill,
OR plus EMD with a stay away from Coffee Emporium. EMD will be able to monitor if he goes to that location.
Your Honor, since I'm not sure if there's anyone working the EMD department today,
There is. Thank you. Nash, they work until
Oh,
12 o'clock.
good morning, Judge Northporter.
Good morning.
Good afternoon, Mr. Nash, not good.
All right, ask the bond.
We'll ask the court for a nominal bond, Mr. Nash is currently serving a sentence.
From the state.
I believe a monetary bond is appropriate. There is a domestic violence protection order issued by the DR court here, and the allegations are multiple walk-ups and making eye contact and then pulling up in a vehicle and speaking to the victim.
$10,000 anyway, plus juris. Hendricks,
There is a request for a temporary protection order on Hendricks, Your Honor.
Who's returning?
James Costin.
Jim, oh, sorry.
waive probable cause,
Yes, Your Honor.
ask to bond.
Your Honor, as a bond, we need to discuss it. So, Judge, he's gonna sign the temporary protection order, but we're asking that he stay with the children.
No.
He'll sign it, Your Honor. Signing now as the bond, Your Honor. Mr. Hendricks is 34 years old. He lives with his spouse and his children. He's employed full-time at Citibank as an account manager. He does have an alternative address to stay with his father in Blue Ash. at 8642 Wicklow Avenue. He's got a good phone number. Their children are ages 8, 6, and 3. This is the first time he tells me anything like this has happened. He's got an OAS score of 1. No record as adult, just with 1 misdemeanor contact. I'm not showing any record as a juvenile. Given the lack of history here, the fact that he's working time, looks like there was one dismissal in 22. But with the relatively small history, his full-time employment, his alternative address with a family member, and signing the PTO, including the children. We asked the court to consider an alternative bond. In this case, EMU plus jurors, if appropriate. Thank you.
From the state.
Your Honor, we'll be requesting a high bond here. The allegation is that he choked her to the point where she couldn't breathe, punched her in the chest, and kicked open a door while holding his youngest son, breaking that door, and then throwing his wife into a closet door, causing visible injuries on her arms, chest, and redness around her neck. And then refusing to turn himself in and being apprehended via flock. I will also note that in the affidavit, the victim states that he left and came back and left and came back and left and came back, indicating that this went on for a very long time. And at one point, his mom was there. And again, allegations that the other children were present as well.
There is 1 misdemeanor, 0 failures to appear. There is a high bond request. The officers requested specifically stating apparently that at some point they had talked to the defendant. He refused to turn himself in, was apprehended via flock with the allegations, and that on the strangulation, 15,000 anyway, plus juris if requested. On the DV, 10,000 anyway, plus juris if requested.
Grand jury report date will be 8/24.
Thank you. Ruff.
Plead not guilty, Your Honor, request probable cause.
Your Honor, on or about July 22nd, 2026 in Hamilton County, state of Ohio, the defendant did knowingly attempt to cause physical harm to DeMarcus Boyd Jr. in violation of 2903.11 of the Ohio Revised Code, felony of the 2nd degree. This complaint states that this is based on victim's statement as well as defendant pointed a gun at the victim and fired a shot.
Your Honor, if I understand, you were drawn to the scene by shot spotter.
I do not have any information about that at this time.
The client was not at the scene. I don't have anything beyond that. If you was shot spotter, I think if somebody shows up in law enforcement garb and you're not supposed to have a gun, you might say somebody else fired the shot. If that's a trial issue. I've represented Mr. Ruff.
Well, hold on, probable cause found based on the reading.
Represent Mr. Ruff for a number of years on various things. Obviously, he should not be around guns. The allegation he had a gun is a trial issue. Strong community contacts, strong family support. I know him since high school, which is not the best thing. You know, criminal defense attorney since high school. But in any of them, he's always shown up with me. He's always cooperated with me. Stays in touch when he's out. Asks for a reasonable bond.
From the state.
Your Honor, given the defendant's history as well as the allegation that a shot was fired at someone else, and the failures to appear as well, the state does think a high secured bond is appropriate.
And then what is, has anyone discussed the traffic cases?
Judge Frank Davis, I'm going to represent him going forward on the misdemeanors. We're hoping that the city is going to resolve this today, given that he has the F2 going on, but otherwise I'll be representing him.
You're looking to resolve today?
If you were willing to dismiss, or he'd be willing to.
Speak to the license forfeiture, dismiss the plates.
What level is this?
Unclassified.
Sorry. We do the unclassified, is that what I?
Yeah.
We can respond.
Mr. Ruff, a guilty plea is a complete admission of guilt. This is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to one count failure to reinstate license? I'll accept the plea. Counselor, do you waive and stipulate?
Yes, Judge.
Finding of guilty, Mr. Ruff has been in one night.
Yes, Judge. We just asked for a counselor.
Anything from the state?
FRA's marked no on the ticket.
One, credit one, remit the fines and costs. On the felonious assault, Mr. Ruff has 3 felonies, 6 misdemeanors, 4 prior failures to appear. There is not a history of violence. The allegations are serious. The bond is $25,000 secured plus EMD.
Grand jury report date 8/24.
Walker,
Straight back across.
Walker.
Morning, Judge.
good morning.
Thank you.
This is Mr. Walker.
All
On
right,
behalf of Mr. Walker, pleads not guilty.
all right, as to bond.
That's the bond, Your Honor. I see that Mr. Walker is 33 years old. He's lived in Cincinnati, the metro area most of his life, and went to Sycamore High School, Judge. I don't see one thing to here which I believe is attributable to this case, Judge. He has no felonies on his record at all. Judge, he agrees to have no contact and stay away from William Peace. The 527 indicates to me that these particular parties are strangers and do not know each other. But I've instructed Mr. Walker to, if he encounters Mr. Peace, to have no contact with him, Judge. I believe the $10,000 bond is excessive. I do have the contact information for him, I have the phone number, and have the address as well. That's for all with the state.
From the state, can you read the complaint? I don't have it in mind.
Yes, Your Honor. The complaint states that on or about June 21st, 2026, in the city of Cincinnati, Hinds County, state of Ohio, the defendant did knowingly cause William Peace to believe that the defendant would cause serious physical harm to the victim, William Peace. This complaint is based on the victim's statements that the defendant did pick up a piece of wood, a 2x4 board, and charged at the victim, causing the victim to believe he would be harmed. The victim had to jump over the hood of a car to escape, with the defendant chasing him with this piece of wood.
So he cannot make any significant monetary harm.
As to bond, state would be requesting a high secured bond due to the nature of the charges. These individuals do not know each other. He's picking up a piece of wood and using it as a weapon, charging of another person.
Mr. Walker has 2 violent misdemeanors, 1 prior failure to appear. This case is a capias, or it's coming out of capias status. The bond will be $5,000 anyway, plus juris if requested.
The court considered alternate or
Leonard,
Leonard. Is Harry Jar here?
good morning,
Only
Counsel.
problem cause plea is not guilty.
As to bond.
Thank you, Your Honor. Ms. Leonard represents me. She's 28 years old, single, with 2 children who live with her. And she's a high school graduate. She's currently going to Ross Medical College for to become a pharmacy tech. She is working and is a home care aide for Aura Pro Novus, where she's been there for 2 years. No prior convictions that I see other than driving charges. She does have some failure to appears, and I said that could be problematic. I asked her about that, and she says that some of the driving issues that she had were in different counties, and with her job and the kids, she had trouble getting to court when she was supposed to. This started when there was a water leak in her daughter's bedroom, and she called maintenance, and they finally showed up. They were leaving. They said they fixed the problem, and she went in the room and visibly saw that it wasn't fixed, and they asked the maintenance guy multiple times to come back and fix it. That while he was still there, to go back in the room so she could show him, and he refused, and she used some really strong language to get him, tell him to get out of her house, and she was angry. She was cooperative with the police when they showed up. She tells me she'll come to court and ask me to consider it or supervise me.
I'm sorry, you said she was cooperative with who?
The police, when the police showed up in the house.
And as to the allegation that she kicked the intake officer?
Can I explain? No.
Let your attorney speak for her.
She denies the allegations.
From the state.
Your Honor, the allegation is that she called for maintenance to come, became belligerent, and then demanded that he leave. And then as the victim was leaving, punched him in the back. And then upon being searched at the Justice Center, searched the wall officer, or kicked the search wall officer in the upper thigh region. I also see 10 failures to appear in the last 5 years, an arrest score 4, and a juvenile felony conviction. We'll be asking for a secured monetary bond.
On the misdemeanor assault, 5,000 anyway, plus juris if requested. On the felony assault against the officer, 10,000 secured.
Grand jury report date on the felonious assault, the 8/24. The other assault is not related.
Thank you. Thank you. Ramsey?
Ramsey, domestic violence docket.
This is a request for order of protection. Ramsey. Is there Ramsey or Ramsey present?
Please not guilty, Judge.
Esteban.
Esteban, I see 0 failures to appear. Mr. Ramsey is executing this protection order. The complaint Says it in one, this is obviously a threat. There's no allegation of any contact at all. It should be import, any threat. Even then, Mr. Ramsey denies these allegations, believes any text or screenshot shown to the police who have been fabricated. We'll litigate that when the time comes. Mr. Ramsey does not live with this prosecuting witness, has no reason to have contact with her while this case is pending. He works at United Direct Solutions. He's an operator here. He's been there for 10 years at that factory. He has 6 kids total, but still 2 minors who live with him. He is the primary breadwinner of the family. Those kids rely on him. Given no record of missing court, the execution of this protection order, what I see is no charges in the last 6 years. We're asking for an OR.
Allegations are a threat to kill made via text. The victim is the child of the defendant. State would be asking for the TPO to be executed, electronic monitoring.
I believe the escalation is because there was a prior DV escalation from him being an M4. OR plus EMD plus juris if requested. There's an allegation of a threat. There are no prior failures to appear. There is 1 misdemeanor, 5 violent misdemeanors, 6 misdemeanors. The allegation is a threat via text, OR plus EMD plus juris with the TPO. All right, so we lock up docket green.
Okay, so let me just green or green.
I did say that you all can call him if you want to call him instead of me.
That's okay, Judge. I'm still learning. It actually helps me to follow it.
Your Honor, we will wait a couple of pause, but I just need clarification on why this theft is listed at an F3 level. Was included.
Does the state have anything?
I will just say that part of it is probably due to the amount. The allegations are that on or about the 27th day of July, 2026, Hamilton County, State of Ohio, did with purpose to bribe Brittany Hancock 4 bottles of methadone without her consent. There are additionally, as well, the defendant cut the power cords to 2 TVs, 3 window AC units, garbage disposal, damaged 3 pairs of Nike Jordans by pouring pasta sauce on the shoes, and then those 4 bottles of methadone without permission. Video footage from the apartment complex hallway shows the defendant coming and going multiple times throughout the night, taking multiple items from the residence. The defendant was convicted of trafficking in drugs in 2018, making the theft of methadone a felony of the 3rd degree.
Your Honor, I would also add that in Ohio Revised Code, statute 2913-02B6, it does become a felony of the 3rd degree if any of the property stolen is a dangerous drug and the offender has been previously convicted of a felony drug abuse.
That's the answer to my question.
All right, thank
May I address the court as it applies to bond?
you. Yes, do you waive probable
I
cause?
do with probable cause.
All right, as to bond.
Esteban, Your Honor, my client is 47 years old. He's a life resident of this area. He graduated from Western Hills High School and has been working temporary jobs on a regular basis.
He has 2 adult children. His last felony from my records was 8 years ago. From my records, it shows no violent history. The only FTA failure to appear he has is one, which is just one traffic matter. He's always showed up for court despite his record. But as I've already indicated, it's been over 8 years ago from my records. My client is very adamant that the alleged facts, the alleged statements from this young lady are not accurate. He did not do these allegations. We are asking for a reasonable bond.
From the state.
Your Honor, I do see multiple. Your Honor, I would request a monetary bond be put in place.
The only thing I will add, it's my understanding that he is still in a relationship with her and they live together.
There are 10 felonies, 2 violent misdemeanors, 10 misdemeanors, 1 prior failure to appear. The record from 8 years ago, he did 5 years and just got out in 2022. So this court is looking at offenses that could have occurred after he was out of jail, not the time he didn't commit offenses while he was in jail. And then it appears there is a lead that does not have a disposition of a 24 federal offense. I don't know if it is pending, it has no disposition next to it for dangerous drugs. On the theft, 5,000 secured. On the criminal damaging, 5,000 anyway.
Grand jury report date will be 8/24. The criminal damaging will go with it.
On the misdemeanor,
The traffic charge, not guilty, RSC.
all right, same line. All right, so
8/24.
Cole, this will go.
This way, Mr. Bryant.
Are you here on Cole, ma'am?
Mr. Bryant. Sir. This way, right back across. Close.
It's my understanding, Your Honor, that this is Lady's officer.
Yes, ma'am.
Yes, they hit my house yesterday and they didn't have a warrant for him. They just had one for my house or whatever. I just want to state that he doesn't stay with me. He stayed with his mom in Town Terrace.
Thank you.
We're not waiving probable causes. It applies to everything except for what was found on this person.
From the, so which count is probable cause being challenged on?
So, I'll go through each count.
All right.
On count A, on or about August 14th, 2026, Hamilton County, State of Ohio, the defendant did knowingly possess Schedule II controlled substance, that being crack cocaine, more than 10 grams, violation of 2925.11 of the Ohio Revised Code, F3. The defendant was placed into custody, searched incident to arrest, found to be crack cocaine on his person. Count B, on or about August 14th, 2026, Hamilton County, State of Ohio, the defendant did knowingly prepare for distribution a Schedule II controlled substance, that being crack cocaine, more than 10 grams, violation of 2925.03, felony of the second degree. Arrestee was placed into custody and search incident to arrest. Search incident to arrest led to discovery of crack cocaine on the arrestee's person. Prepared for distribution within 1,000 feet of the Rothenberg School. Count C, on or about 8/14/2026, Hamilton County, State of Ohio, defendant did knowingly possess Schedule II controlled substance, that being meth, less than bulk amount, violation of 2925.11, the Ohio Revised Code, felony of the fifth degree. During the execution of a lawful search warrant, Pivot recovered meth in the arrestee's bedroom. package for distribution, along with packaging material, drug paraphernalia, U.S. currency, and a firearm. Count D, on or about 8/14/2026, Hamilton County, State of Ohio, defendant did knowingly prepare for distribution Schedule 2 controlled substance, that being meth, less than a bulk amount, violation of 2925.03 of the Ohio Revised Code, a felony of the 5th degree. During the execution of a lawful search warrant, Pivot recovered meth in the arrestee's bedroom packaged for distribution, along with packaging material, drug paraphernalia, U.S. currency, and a firearm. Count E, on or about August 14th, 2026, Hamilton County, State of Ohio, defendant did knowingly possess Schedule 1 controlled substance being psilocybin in less than a bulk amount, violation of 2925.11 the Ohio Revised Code, felony of 5th degree. Again, during that execution of a lawful search warrant, Pivot recovered in the in the arrestee's bedroom package for distribution, along with packaging material, drug paraphernalia, U.S. currency, and a firearm. On or about August 14th, 2026, in Hamilton County, State of Ohio, defendant did knowingly prepare for distribution a Schedule 1 controlled substance, that being psilocybin, thank you, less than bulk amount, in violation of 2925.03 the Ohio Revised Code, felony of the 5th degree. Again, during execution of a lawful search warrant, Pivot recovered that drug in the defendant's bedroom, packaged for distribution, along with packaging material, drug paraphernalia, U.S. currency, and a firearm. Weapons under disability, on or about 8/14/2026, Hamilton County, State of Ohio, did have a firearm, that being a black Glock 45, having been convicted of an offense involving the illegal distribution, trafficking, and a drug use. Violation of 29.13 of the Ohio Revised Code, felony of the 3rd degree, was found to have that in his possession during a residential search warrant. The allegations in the arrest report further support this, being that there was a search incident to arrest, led to the discovery of crack cocaine on person within 1,000 feet of the Rothenberg School. That residential search warrant was executed at what the police have labeled as the defendant's residence. During the search of that residence, a Glock handgun fully loaded with extended magazine was recovered, along with meth, crack cocaine, psilocybin, paraphernalia, packaging material, and U.S. currency. Brief summary by the statement: my DNA is on the gun that was found in his room.
Probable cause is found. It appears that there was a search warrant at some point. With the search warrant, someone was presented enough that they believe Mr. Cole either resided there or what have you, that they got the warrant and either resided or frequented there, I don't know, but either way, the other allegation as far as to what was found not on his person, but in a room, the allegation is that there was an admission that the DNA, his DNA was on the gun found in his room, that this is a statement by him. And so for purposes of probable cause, there is a finding of probable cause as to bond.
As to bond, Your Honor, my client is 35 years old. He's a life resident of Hamilton County. He has acquired his GED and he does work custodial jobs on a regular basis. He has 2 minor children, ages 6 and 12. I want to repeat that my client does not live at this residence. He does not stay at this residence. He denies that there's that he made any admission regarding his DNA being on the gun. It's my understanding, I don't know that this gentleman, Mr. Payton, is a co-defendant that's in there, but he was actually staying with the young lady who just spoke and has also been charged. My client's last felony was 10 years ago. My client is very adamant that he actually lives at 2763 Town Terrace Drive. We're asking the court to please consider a reasonable bond.
Is there anything from the state?
The state does think that a monetary bond is appropriate. Again, I do see a conviction for weapons under disability in 2023. I see the aggravated trafficking in drugs in 2018. Again, this is all taking place within 1,000 feet of a school. This is very concerning. the allegations. I think there's even more similar convictions for possession of heroin. Again, weapons under going even further back. So given the history of the defendant as well as the allegations, a secured monetary bond is appropriate.
There is convictions, 1 violent felony, 6 felonies, 1 violent misdemeanor, 7 misdemeanors, and 6 prior failures to appear in the last 5 years. On the F3 possession, 10,000 secured. On the F2 trafficking, 20,000 secured. On the F5 possession, 5,000 secured. On the F5 trafficking, 5,000 secured. On the F5 possession on the E count, 5,000 secured. On the F5 trafficking, 5,000 secured. On the having weapons under disability, I'm sorry, did you say there was a prior conviction for that?
I did, so, yes. In 2023, he passed away. I see it. It's case number B23036713. It says sentence defendant. I think that says probation.
20,000 secured.
Grand jury report date will be 8/24.
Demetrius Cook,
This way, Cook, straight across. Come on, Cook. Go.
Mr. Cook, Your Honor, we'll waive for him about the felony.
Esteban.
Mr. Cook's 41 years old, lives locally on Dick Avenue here in Cincinnati. Give me a good phone number. He lives with his mother. Police are asking for a high bond, but I would advise the court that Mr. Cook tells me that he suffers from sickle cell anemia. And that may explain some of the circumstances, but he tells me that he experiences a lot of pain. We would like the court to take that into consideration. Is that fine? Thank you.
Is he in the middle of a pain crisis? No.
Indicates that he is, Your Honor.
From the state.
Your Honor, we'd be asking for a monetary bond. Defendant was found after an anonymous call. There was a group of people standing in the street causing a traffic hazard. And then when police arrived on scene, arrested the defendant, and in a search incident to arrest, they arrested him on an open warrant, I should say. But in a search incident to arrest, he was discovered with heroin, I believe, in his shoe. Sorry, I'm looking at a lot of papers. Yes, he admitted to that being heroin, discovered in his left shoe. And I'm trying to read the officer's handwriting about how much it was. Less than or equal to 4.99 grams.
What is the, all right. On the misdemeanor Esteban,
Thank you, Judge. This seems to be the warrant that led to the search. This is a situation from Mr. Cook doesn't know this person, doesn't know where this allegation is coming from, has no recollection of what would have led to a warrant, which obviously led to this search. and this new charge.
Is there anything from the state?
It'd be from the city.
Is there anything?
Aggravated menacing.
I haven't put the city on it.
I have the jacket here. Allegations, just so the record's clear, are on or about April 28, 2026, did knowingly cause Haley Fryman to believe that the defendant would cause serious physical harm to her. Victim and witness stating that Mr. Cook told the victim, "You're gonna die tonight and you aren't leaving here tonight." This is based off of the victim's statements and the witness's observations.
On the ad menacing, it looks like that was from April. OR plus jurist if requested. On the impeding the roadway, OR. On the felony, there are 10 prior felonies, 8 misdemeanors, 4 prior failures to appear. On the F5, the bond will be 10,000 anyway. Dykes,
Grand jury report date is gonna be 8/24. The aggravated menacing will not go, but the empty soliciting will.
thank you.
Thank you.
Dykes.
Ms. Dykes, Your Honor, we're waiting for our
As the bond,
bond. She's 29 years old. She has a 2-year-old child. She lives on Franklin Avenue here in Cincinnati. Her phone number, she's employed full-time at Western Nursing Services. Submit on that.
from the state,
Your Honor, I will note that she has an ORS score of 6 and 22 failures to appear in the last 5 years. The allegation is a theft from Aloe in Kenwood of $2,041.74 and possessing magnets and aluminum foil to remove security sensors.
there are 7 prior felonies, 6 misdemeanors, as the state said, 22 failures to appear. At least 4 of those are thefts, and it looks like Ms. Dykes did 15 months for theft and was released in 2024. $5,000 secured on each count plus EMD restricted hours. Stay away from all Aloe stores and Kenwood Mall.
Grand jury report date of 8/24.
I'm gonna go young lady.
Greer,
Greer. Can I go with this? There's right in there. Yeah, to the office.
Mr. Greer, Your Honor, we'll waive the reading of probable cause on the felony.
All right. As to bond.
As a bond, Mr. Greer is 69 years old. He lives locally here on Randy Avenue in his own apartment. His source of income is pension and Social Security. Judge, I think the felony charge that's listed, he tells me it's from 1977. So this is a 50-degree felony. You have to take that into consideration as we consider getting that on bond.
You mean a prior felony, not the one
Yes.
he's charged with today? Oh,
Correct.
Judge, we would like to resolve the shadow cases. I have a resolution of the city, of the county, just to cease those two.
Oh, he's got to plead to the speeding too.
Great, we'll plead to this.
And Judge, as to the city matter, linked to the 26 city traffic ticket, that's the A and B, the 1510.16, as well as the unauthorized place. The balance of the city will be dismissed with plea.
is that the case 13765?
Yes.
Yes.
Plead to that, dismiss the rest of the city charges.
And then the 26 speeding, and then the county is dismissing the remainder of the traffic.
Correct.
Deal.
What's the level of the city driving under?
This is an unclassified felony.
Mr. Greer, a guilty plea is a complete admission of guilt. The driving under suspension is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. The speeding and the unauthorized license plates are minor misdemeanors. Maximum possible penalty is $150 fine plus costs. You do have the right to a trial on all the charges. Knowing your right to a trial and the maximum possible penalties, do you want to maintain a guilty plea to the 3 traffic offenses? You have to say yes or no out loud. sir.
Yes, ma'am.
Counselor, do you waive and stipulate?
Yes, ma'am.
Finding of guilty, Mr. Greer has been in for one night.
Yes.
Is there anything else from defense? Anything from the state?
Yes, you're,
On the traffic matters, just on the traffic matters, I've already marked down.
After that, it's marked down on the city as well.
Mr. Greer, did you want to say anything on the traffic offenses? You have the right to, but you do not have to, just on the cases that you just pled to.
No.
All right, from the state on the felony.
yes, Your Honor, the state would ask for a monetary bond, just due to the fact that the defendant has 7 previous failure to appears in the last 5 years.
On the F5 possession and the M4 possession, the bond will be OR plus EMD. The EMD is because of the failures to appear. There is 1 violent felony, 2 felonies. And as counsel stated, it looks like those offenses were from the 70s. The failure to appear come from all of the traffic offenses. Harris,
Do 831 that for grand jury report date.
Thank you.
This way, young man.
Are you gonna do it on both or just?
Yes, for both, we'll go together,
Okay.
thank you.
Thank you.
So straight back to Sean. Paris. Paris.
Judge will waive probably class two, is not guilty.
As the bond.
This case represents to me that she's 29 years old, single, with one daughter, a 10-year-old daughter that lives with her, high school graduate from Don Community High School, currently employed doing home health care for all of you, more where she's been for 8 months. I see no prior felony conviction. She does have misdemeanor contact. Just as a
There are
record
two.
keeping, one of the offenses is charged on August 8th. And it's my understanding that both of these offenses, if they occurred on August 14th. She was incarcerated, she tells me she was incarcerated on August 8th.
Incarcerated where?
In the County Justice Center.
Yeah.
Not the incarcerated. Zenith.
I believe it most likely is August 14th because I believe this to be the co-defendant on the other Allo case that we just heard.
That's correct, Judge.
It was the same amount that was, all right.
So Judge,
Yeah, well, the B charge has the 14th. The A charge, they put the apparently.
I'll move to amend it to August 14th, just for clarity of the record.
The amendment will be granted. Continue.
And Judge, my understanding, all the goods, merchandise was returned. She was cooperative. The police came while she was at Lululemon, and she was cooperative with the police at that time. She has $500 available for her.
From the state.
I'd ask for the bond to be similar to the one that the court put in place for the co-defendant. Again, this is a substantial amount. There were possession of criminal tools in that case. I do also see 2 felony convictions, 13 misdemeanor convictions, and 4 failures to appear. I see a theft conviction as recent as 2024, but it seems to be a reoccurring pattern.
Ms. Harris has 2 felonies, 13 misdemeanors, 4 prior failures to appear. At least 4 of those are theft convictions, with Ms. Harris just getting out of Warren County Jail for theft on June 15th of this year. On the A count, it'll be the same as the co-defendant, 5,000 secured plus EMD restricted hours with a stay away from all Allo stores and Kenwood Mall. On the B count, 5,000 secured plus EMD restricted hours. On the misdemeanor theft, oh, that's from Lululemon.
Yes, Your Honor, it appears that this was two different shopping incidents. So it says on that same date, 20-30 hours, listed arrestee and co-defendant knowingly obtained control over $2,041.74 worth of merchandise from Allo and Kenwood. Then the listed arrestee then knowingly obtained control over $465 worth of merchandise from Lululemon. They walked past all points of sale. then also in possession of those criminal tools previously mentioned.
2,500 secure plus EMD, restricted hours with stay away from Lululemon. And Kenwood.
Grand jury report date will be 8/24 on the felony.
On the misdemeanor traffic,
Judge, we just entered not guilty. And that's for all the bond.
there are 3 prior failures to appear. On the A charge, it'll be the same bond. On the B charge, the minor misdemeanor OR. Mallory,
That was 8/24 on both of the left.
Okay.
Mallory.
is the Lululemon going with the other?
Let's say no, let's already see that one.
Okay.
Good morning.
Thank
As, weigh probable cause.
The way probable cause, please not guilty charge.
All right, as to bond.
Mr. Mallory represents the need that he's 26 years old, single with 3 children. One of them stays with the defendant. He lives in Dayton, Ohio. He's been in Montgomery County for 6 years. After that, he was from Georgia. High school graduate. He has trade certificates in facility maintenance and culinary arts. Currently employed at Amazon doing delivery for the last 2 years. I don't see any prior convictions. He adamantly denies this, doesn't know the victims, doesn't know how this came about. Low or score, tells me he was cooperative with the police, and it shows that he has 2 failures to appear. He said he didn't know what that was about. He's a kind of poor child.
The 2 failures to appear to be the misdemeanor charges that are pending. There is a obstruction from 2024.
Your Honor, they told me they.
Hold on 1 second. Let the attorney speak for you. All right, Mr. Mallory. And then there is both of these there's one on each case. There's a traffic and the obstruction from 24. That's where they're counting the failures to appear. How was Mr. Mallory taken into custody? Did he turn himself in or was he taken in on something else?
So my understanding is he was at work and the police came to work on a warrant, and he was cooperative with the police. And he just mentioned to me with regard to the obstructing official business in 2024, that he had been before that case had been dismissed.
From the state?
Yes, Your Honor. So the allegations are that Mr. Mallory took a Wells Fargo credit card, a Capital One credit card, and a West Banco debit card from a Miss Emily Stapleton and attempted to purchase 3 American Express cards valued at $500 each. And he was, according to the complaint, arrested pursuant to investigation and surveillance. So the state would ask for a monetary bond. In addition, there were the 2 FTAs in the last 5 years. And then there is an allegation that he, on one of the traffic series, that he fled a traffic stop and caused an auto accident. So there are some concerns about the two.
Well, maybe that's where he got the dismiss from, because the fleeing and eluding, it appears, was ignored. And then the others, which includes an accident, went through to,
It looks like the traffic was set for plea, and then there was a jury trial setting on the obstruction.
that is correct for the misdemeanors. That's where the failures to appear come from. But the only fleeing and eluding that I have was ignored. I'm not going to do EMD because Mr. Mallory lives out of county. On the felony receiving stolen property, it's a F5. It'll be 500 anyway. The misuse of cards will be OR. The obstruction, I'm putting nominal bonds because the court is not doing EMD and there are 2 prior failures to appear. But as we stated, Mr. Mallory has no record. So the bond on the obstruction, capious, is modified from 1,000 to 500 anyway. And then OR on the 2 traffic were 1,000 each. Those are modified to OR.
Thank you.
Morel, 824, grand jury report date.
Morel has a comment, please.
Ms. Western. Straight back across. Morel.
Your Honor, Mr. Morel is being represented by Bill Gallagher, and I'm standing in for him today. Mr. Morel tells me that it causes him great pain to stand up right now, so I told him he would have.
You can remain seated.
Waive probable cause, Your Honor.
All right, ask the bond.
Esteban, Your Honor, Mr. Morel was out on EMU. Apparently this resulted from an accident where Mr. Morel was hit by a car while he was on an electric bicycle. There's allegations that he was trying to flee police at the time. I'm not sure exactly what happened, but obviously he was seriously injured. I know that he was working full-time, but not making a whole lot of money, Judge. He's a lifelong resident of the Cincinnati area, lives here in Hamilton County, and is a high school graduate from Hughes. He is already in front of Judge Luberst on another matter, and was out on the EMU on that, and is asking the court to restore his EMU.
In the state.
Your Honor, we'll be asking for a secured monetary bond on this one. He has 9 felony convictions, 12 misdemeanor, and 2 failures to appear in the last 5 years, as well as 4 pending felonies. My paperwork shows that his case with Judge Luberst is in capious status. I would also note that he was carrying a bulk amount of marijuana packaged for distribution, or at least alleged to. To enlighten the court about the traffic, he ran a stop sign allegedly on an electronic dirt bike with no license plates. Officers initiated their overhead lights and sirens, signaling the defendant to stop. He initially pulled over and stopped. Officers could smell marijuana emanating from the backpack. They ordered him off the bike. He ignored those commands and fled from police. He was then observed by plainclothes officers continually operating recklessly, running red lights, swerving all over the road until he caused a serious injury accident in the intersection of Lincoln and Victory Parkway. There is a request for a high bond here. It says that he is also currently on probation and is on EMU for drug trafficking and fled from a lawful traffic stop. Ran every red light during his flee.
And Judge, these are all felony fours, and just want to bring to the court's attention again that this happened just a couple days ago. He is the serious injury from the accident. He's going to require further medical attention.
On the 2 minor misdemeanor traffic OR. On the other, the court typically does not put monetary bonds on low-level marijuana offenses. But there are 9 felonies, 12 misdemeanors, 2 prior failures to appear, and the defendant is currently on probation for a drug offense and has pending charges for the exact same offenses, which include trafficking marijuana, possession of marijuana, and then failure to comply. On the A, trafficking 5,000 secured. On the B, possession 2,500 secured. On the failure to comply, 15,000 secured.
Grand jury report date of 8/24.
Nyan,
Traffic with it.
Your Honor, we'll waive probable cause.
Esteban.
Esteban, Your Honor, my client is 28 years old. He's a life resident of Hamilton County. He's an Euler High School graduate, and he actually attended the University of Cincinnati and obtained his BS in finance. Although he does not have a job in finance, he has been a mechanic with his father's automotive business as a paint auto since he's been a teenager, young man, Your Honor, so some time. Apparently he has put that use of his degree, and he's a very successful mechanic and has a business where he, what I would call almost like a bootleg rental car company, where he will rent out his cars. He adamantly denies, I know this officer is just as adamant that this is a young man who was driving the vehicle that did not comply with his orders. But he is very adamant it was not him who was driving. When the other young man did not return the vehicle, he indicates he did file a police report with District 3. When he was able to locate his car, he actually went into the police to be able to get his car back. I think common sense would say if he had actually been involved in the failure to comply, he would have not done that. He seems to have, a very stable lifestyle. He has a very low OR score at 2. We are asking the court to please consider a lower bond, but the court would be inclined to possibly even allow an LREMT.
From the state.
Your Honor, the state is requesting a secured monetary bond due to the allegations. The allegations do state that the defendant reversed aggressively at a fast speed toward an officer, nearly striking his cruiser, observed the defendant through the windshield, still seated in the driver's seat, did not see any other occupants in the vehicle, and there's an allegation that the defendant peered at the officer and began accelerating the vehicle again. sped past the officers, struck garbage cans in the grass, and nearly struck the cruiser again. The defendant also has 4 failures to appear in the past 5 years. And the officer also did obtain security videos, body cam from a recent traffic stop at Block and his DMV photo, and states that he is positive that the defendant was driving the car at the time.
I just don't know how a police officer can tell who's driving a vehicle that is not compliant. Like, I mean, it's adamant it was not him.
Your Honor,
Please.
Okay. Let your attorney speak for you, all right? There's 2 felonies, 2 misdemeanors, 4 prior failures to appear. $5,000 anyway, or alternative ORND. Peyton,
Grand jury date will be August 31st, 24th, excuse me.
21st.
Just wait, I'm gonna take the orientation.
24.
It'll be 8:31.
Peyton?
good morning.
There should be not guilty on behalf of Mr. Payton, and as this was conducted pursuant to search warrant, we will waive probable cause at this point.
Esteban,
Judge Esteban, this is Mr. Payton, first real contact with the court system. Judge, he has 1 prior conviction, it was a misdemeanor. Judge, I will be very honest, that conviction was about, I believe about 4 years ago. No recent contact since then, Judge. I think there was a felony that was ignored, nothing ever came of that. Judge, he has no failures to appear in the last 5, so even despite having that 1 misdemeanor conviction, he does show up for court. Judge, this is the co-defendant case to the case of Mr. Cole that was referred earlier. Judge, Mr. Payton also does not reside at that residence. He resides with his mother and his younger brother over at West Mills Lane. The reason that we are very adamant about that address is he's responsible for driving both his mother and his brother to and from work, to and from school each day. Judge, that would not be feasible. He does not already live there and reside with them. He does own his own business. He owns a cleaning company called Awesome Jackson. They go in and they're responsible for carpet cleaning and carpet management techniques throughout Cincinnati. Judge, Mr. Payton did attend some college at UC, and he's actually re-enrolled at Cincinnati State trying to get his real estate license. Judge, these charges are very surprising to see in somebody that has the resume that Mr. Payton does have. Very limited court contact, almost no convictions with the exception of 1 misdemeanor. Judge, my apologies. It is important to note, as I believe Ms. Gano did for Mr. Cole, that this was a search warrant for an address, not for a person. Judge, my understanding is that none of these items based on the complaints were found on Mr. Payton, in his car, on his person, or even in his vicinity. They were located rather at the residence when Mr. Payton was visiting his cousin. Judge, Mr. Payton was nothing but compliant with officers, answered their questions as asked. However, none of these charges were from anything found on Mr. Payton or near him. We'd ask Your Honor to consider an OR or an SOR.
from the state.
Your Honor, Mr. Payton did admit to living in the residence, and also admitted specifically to living in the room where all the drugs were found and possessing and using all the narcotics recovered. I would note again for the record, these are some very bulk amounts of different methamphetamine, crack cocaine, psilocybin, marijuana, marijuana prepared for distribution, and firearms also involved. Relevant here is a loaded Taurus handgun and a loaded Ruger handgun recovered along with the meth, crack cocaine, psilocybin, marijuana paraphernalia, packaging material, and U.S. currency indicative of drug trafficking and preparing drugs for distribution.
As was stated, Mr. Payton has no prior record except for a minor misdemeanor, no prior failures to appear on the A possession, which is an F4. Possession of crack, 2,500 anyway. On the B, that is a felony of the first degree, is that correct? What is the amount?
Just a second, I'm sorry.
Judge, I believe the complaint just says one goal.
It does say one. But it is charged. It's-
$5,000 secured on the F2 meth, 5,000 anyway. On the marijuana OR, that's the D and the E. The F charge, 2,500 anyway. That is another count for crack cocaine. The F2 meth, 2,500 secured. And the other F1, 5,000 secured. Pierce,
Judge, if I can grand jury report, please.
I'm so sorry. That's gonna be the 24th, August 24th.
Thank you.
Yes, sir.
on Pierce,
We'll wait probably.
Pierce.
We'll wait probably.
all right, as to bond.
Esteban, Your Honor, my client is 24 years old. He's a life resident of Hamilton County. He's a Don graduate. He did attend Cincinnati State and Chatfield, a number of classes, but did not get his associates. He has been working at Pride staff doing warehouse work for a number of months. The only conviction I have is one misdemeanor in his past. I am understanding he has no juvenile record. This is a nonviolent charge. It's a nonviolent record, no felony record. He is very adamant that this is not a predominant of the young ladies here that he was visiting. He certainly has every right to be over there. He was just trying to find out if she or her mother were home. And he denies any tampering. The landlord, who is the landlord for this young lady, is in a significant relationship with, is just very disgruntled and does not like visitors like this. And he was just trying to see if she or the mother was home, and he denies that he did anything to her in the video camera.
From the state,
Your Honor, there appear to be 7 failures to appear within the last 5 years, but I'll also note that there is surveillance video that shows the defendant improperly tampering with the wires in the basement of the property that was not his own. And in the process, the defendant did destroy the camera, capturing the said video surveillance to conceal the act of tampering and his presence on the property. That this is an allegation of tampering with evidence, and it did destroy a thing with the purpose to impair its ability as evidence in such investigation, which is a very serious allegation. I do think some monetary bond is appropriate.
The only thing I'm going to add is the 7 doesn't make any sense regarding the number of times he's even had a conviction, which what I'm showing is just one conviction. He's very adamant he's never missed court. So that 7 number is an error administratively.
I have one conviction. I can have them checked because the failures to appear are, my only assumption is there is a significant amount of traffic, that they may be on traffic offenses. There's 1, 2.
The only thing I would add, Your Honor, is that he's saying he's always been there for traffic even, but if the court is inclined, we would ask to consider an OR if the court is concerned about appearing.
That's what the court was gonna do, it would have been straight OR without the failures to appear, but with the failures to appear is OR, EMD. The EMD will be open hours. I just care about Mr. Pierce coming back.
Grand jury report date will be 8/31.
Williams,
Pierce.
Here we go.
Pierce.
Judge will waive probable cause, please not guilty.
all right, as designed.
Your Honor, Mr. Williams represents the following to me. He's 29 years old, single with 5 boys, and he splits custody with their mother. So they stay with him 1 week, with his mom the next week. Went to school for 12 years but did not graduate. Currently employed with all in construction, where he's been for 2.5 years. No prior felonies that I can see, which would mean that he's under no disability for having a firearm. His misdemeanor contact looks to be all traffic except for 2 offenses in 2016 and 2018 respectively. With regard to this offense, he got pulled over. He was driving his girlfriend's car. Girlfriend was in the car. He got pulled over because the sticker on the back of the car had expired. Girlfriend had the evidence that she had paid for the new registration, but didn't have the sticker on the car. Mr. Williams denied having a firearm in the vehicle when the police approached the car and asked him. That was a mistake. They saw a burnt marijuana cigarette in the ashtray. It gave rise to their probable cause of search his vehicle. No indication of impairment, no indication of smelling smoke.
Does Mr. Williams have somewhere to go on EMD?
Yes, ma'am.
All right, is there anything from the state?
Yes, Your Honor. The PSI report does recommend a high bond, and the state would agree and add that the gun that was located was a black Glock handgun underneath the driver's seat. It also had 19 live cartridges, although none were in the chamber. And as stated, he did not disclose the presence of the firearm to the officer when asked.
The judge also, he told,
Mr. Williams
Yes, ma'am.
has 1 prior violent felony, no other record, nothing as a juvenile, 4 prior failures to appear. That's the reason the court is doing EMD. Mr. Williams is legally not forbidden from having a firearm. The allegations stem from Mr. Williams allegedly saying that there was not one in the car, but he, from all intents and purposes, and there is not a weapons under charge, is legally permitted to have a firearm. The court it'll be OR EMD. Again, the EMD is because there are the 4 prior failures to appear, but it'll be, and then on the traffic, it is straight OR.
Grand jury date of August 31st.
Pelfrey,
You said Pelfrey on Pelfrey.
It'll be on everything.
Yes.
Mr. Pelfrey is right there.
And traffic will follow the grand jury date of August.
Good morning, Mr. Pelfrey. Yes. You waive probable cause? All right. I said, Mr. Pelfrey has 3 felonies, 1 misdemeanor, 0 prior failures to appear. The allegation is that the defendant admitted to the offense, turned himself in, The officer requested a low bond when the court set evening bond yesterday. The court set an OR bond and Mr. Pelfrey showed up today. Is there anything from the state?
We just asked for a stay away, Your Honor.
OR plus stay away from, where's the stay away location?
Noramco Transport.
OR plus stay away from Naramco until further order of the court or until the case is resolved. All right, thank you.
August 31st, grand jury report date.
Brandon Cook.
Cook.
Let's check on
Brian Davis from Mr. Cook. Please will be not guilty for the M1 and the M2. We may have a resolution on some of these others.
The state would ask for a guilty plea to both charges on C26 TRD 15780, and the county will dismiss the other two charges per plea, or the other two tickets per plea.
Amending that to
It will be stipulated as unclassified.
We can resolve for that.
Mr. Cook, a guilty plea is a complete admission of guilt. The red light violation is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. The driving under suspension is is being amended to an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs up to 500 hours of community service. The driving offenses are offenses that enhance, meaning that additional convictions of the same offense can result in additional more severe penalties. Specifically, it appears from what this was charged as initially before it was amended, that there are traffic offenses escalating these from a level that does not carry jail time to a level that does carry jail time from driving. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to driving under suspension and a red light violation?
Yes, ma'am.
Counselor, do you waive and stipulate?
Yes, sir.
That includes waiver of service of a new complaint and arraignment. Finding of guilty. Mr. Cook has been in for one night.
We just asked for a concert.
Anything from the state?
FRA is marked no.
One, credit one, remit the fines and costs. As to the other bonds,
And just to clarify that the 25 TRD 31370.
dismissed for plea.
Thank you. As to the other bonds, Mr. Cook does have some medical issues. I believe he has a broken wrist with a metal piece in his wrist that is broken. He is trying to get a doctor to see that. We're asking for an OR so he can get some treatment for that. He does have custody of one of his kids. I'm seeing no violent criminal history. I'm sorry, two of his kids. I'm seeing no violent criminal history, no felony history that I can see. I have good contact with Mr. Cook, so under those circumstances, we're asking for an OR.
From the state.
Your Honor, Mr. Cook does not come to court, and he also does not comply with the lease. So I would ask for a monetary bond plus EMD.
There are 5 prior failures to appear. I will change the bonds back to the bonds that I set before Mr. Cook Capias again. It'll be 1,000 plus EMD on the unauthorized use, 2,000 plus EMD on the obstruction. Fairbanks,
This way, Mr. Cook.
all right, Esteban.
This will be a conflict, but as to bonds, we're asking for an OR or an alternative EMU. Mr. Fairbanks does have a job pending. He can work at a junkyard with his brother. He's just waiting for that application to go through. I have good contact with Mr. Fairbanks. He has good housing. He's okay with having no contact with the alleged victim in this case.
From the state.
The city has the assault charge, the county has an FRA suspension.
Yes, on the assault charge, the city thinks a monetary bond is appropriate, as well as a stay away to the requested allegations are that the defendant knowingly caused physical harm to the alleged victim by punching her in the face, hitting her in the leg with a tree branch, causing physical injury, scratches and bruises.
There's 1 violent felony, 5 felonies, 3 misdemeanors, 8 prior failures to appear, 5,000 anyway, plus EMD, plus juris if requested, OR on the traffic. Hopkins,
This way, Mr. Fairbanks.
Straight back over here. 5K, 5K plus EMD. Hopkins. Mr. Hopkins. Okay. Mr. Hopkins.
Yeah.
Be quiet. Don't talk. Don't talk. Right after your turn.
all right.
They're gonna do how he wants to do it, so we already know. Go ahead, you're from the show. I'm serious, guys.
Mr. Hopkins.
All right. Is there a plea of not guilty, counsel?
Yeah.
Yes.
Esteban,
Esteban, Mr. Hopkins formerly lived at the place on which he was trespassed. He understands that he's still permitted to do that. I am his attorney representing him on the other charges. It's not the same location, it was a Shell station. And the accusation of the theft from the Shell is that we took some bottles of water and some candy.
This ain't about sale, this is about trespassing. So, yeah, this ain't about sales.
Mr. Hopkins,
Let's make sure.
Mr. Hopkins.
This thing's gonna go crazy later.
Mr. Hopkins, if you would stop talking and listen to your attorney, you would understand that the argument that she is making sense. that you are not, this case is not related to the other case, which makes a difference.
44, dude, that's all I'm saying, dude, it's gonna happen, dude, it's real. All it is, guys, I'm not trying to get out.
None of the allegations are violent. You can make sure that Mr. Hopkins has a solid place to stay.
Girl, I had a solid place to stay, ma'am, I was evicted out of my trailer, right?
From the
So,
state.
Yeah.
From the state, Your
I got a
Honor,
solid place to live.
the allegation is that he had been told earlier that day not to come back and then came back anyway. I was just gonna note the currently pending charges, and I would ask for a stay away.
Yeah. Yeah, man. Oh, yeah, it's gonna happen like that. No.
You said your office is gonna find a sister with somewhere to stay.
Oh, man, I don't need nowhere to stay. I got family, real family in Wisconsin. And I got friends in Hammersville, Ohio.
OR plus EMD, restricted hours.
EMD?
King,
What was it?
Did you bring the stay?
No, it's, I don't know what it was, EMD? What's that, electronic? It ain't gonna work, dude. Oh, you did?
Your Honor, for my papers, did you grant the stay away?
oh, you know what? Yes. Can we just bring him right back to the door? That's it. Mr. Hopkins, yes,
Okay,
just
King.
to the door.
Mr. King, come back over.
5833
You
Stewart.
have to bring Hopkins right back to the door. Mr. King just.
No, I'm saying you need to write something.
No.
Okay.
Stand right here, just right here, and listen to the judge. Stand right here and
There's a
listen.
stay away, no contact from the store.
From the store?
Yes, sir.
Who owns the store, man?
From the,
Is it a?
Hey, my family owns the
Oh, it was a
store,
mobile.
dude.
What was it?
I know, so. This show's done by people in my family.
All right, that's great.
It really is.
On
Stay away
the
from the store.
It's not gonna
west,
be-
is it
it's gonna be the one that
Westbrook?
press charges.
What is the name of it?
5833 Stewart.
Westbrook Village.
Thank,
Thank you.
all right, now, Mr. King, thank you.
Come on, Mr. King.
Sorry, Mr. King.
Meg, back to Mr. K. So for the traffic, I think we'd like to resolve this here.
Are there city traffic?
No, they're county from 24. Oh, it's only one, is it?
Yeah, the only county matter is that traffic, 24 traffic matter.
Guilty plea or no contest?
I think there's no accident, so it's fine.
Mr. King, the guilty plea is a complete admission of guilt. This is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to driving under suspension? All right. Counsel, do you waive and stipulate finding of guilty? Mr. King has been in for one night. Anything from the state?
Just an insurance was not shown.
One, credit one, remit the fines and costs.
As to the remaining, Judge, if we could break apart the assault for a second, I think that's a Sears case, this is June 25.
Anything from the state?
Stick with that, to stay away, allegations of unknowingly pulled the victim's hair, twisted the victim's neck, pushed the victim to the ground, 53, complaints based on victim's statement.
OR plus stay away. Mr. King has 2 felonies, 1 violent misdemeanor, 1 violent felony, 2 prior failures to appear. That charge is over, it's from 2025. And obviously there has not been anything until present because he would have been arrested in between that time. All right, as to the new case, These are all M4s. Is there anything from the state?
One should be an NF. The open container should be an NF.
Anything from the state?
Nothing from the city as to the failure to disclose.
Supervised or? Lee?
Inquiry for Mr. Lee, this is a judge set bond.
Anything from the state?
No, Your Honor.
It will be the same bond. Anthony Nuttall,
I'm designating Mr. McKenna on this case. He has these underlying charges.
That's all.
Inquiry for Mr. Nuttall for today, but he's not guilty. So this VPO judge has to do with these brand new underlying charges. You'll see that this happened not in anyone's home, but in a park. What was actually going on was that Mr. Nuttall had recruited his brother, who didn't have particular knowledge of the TPO, to help him move items out of the house. They did that and brought them to a park. Mr. Nuttall is a tattoo artist, so he had a lot of equipment in there, and they had set it down in the park in order to arrange transportation. And unbeknownst to Mr. Nuttall, the prosecuting witness had been called and bribed his brother. He was gathering his things. I think police stopped because they thought that there was some sort of encampment or sale of items going on at the park. So this is not a situation where prosecuting witness is in a place that Mr. Nuttall actually goes to in order to contact her. I think this is a chance encounter in a place that Mr. Nuttall was attempting to leave. I don't think that this will be found to be a reckless violation. He understands the terms of the VPO and can explain them to his brother as well. And I would assume now, for the first time, the prosecuting witness also understands those terms. But it's my understanding, based on the underlying OR bonds, that this is something that the prosecuting witness doesn't want to participate in anyway. But he can stay away, has another place to stay, was in the process of moving out, and has good contact with his attorney.
from the state?
Your Honor, the complaint does say that the defendant was found with the protected person at the park. So just want to make a note of that.
Supervised or? Bishop?
Or, Bishop? Bishop?
Hold on. Let's do this and then I'm gonna do the walk in. So the person show.
Judge, first we're going to enter a not guilty plea.
All right.
And then as to bond, in reading the complaint, I was considering challenging probable cause to hold here. However, in reading the 527, I think that they do meet that low burden or that low threshold, Judge. However, I was a little confused by some of the comments in the 527 because Mr. Bishop, I was looking through his record, looking through all of the criminal trespasses, all of the disorderly conduct that he's ever gotten. He's never had one at this location before, Your Honor. And so I find it difficult to believe that he's, such a nuisance that he's always coming back, when he's never actually been charged with trespassing in this place. So, Judge, I'm going to be filing for discovery. We're going to be fighting this case, and the state's going to need to provide me with these prior trespass warnings that they are alleging did occur, Your Honor. I would note that everything before you is non-violent. The two probation violations are both fourth-degree misdemeanors, Your Honor, and Mr. Bishop has been staying away from the connector where he had been trespassed from. Judge, he has no failures to appear in the last 5 years, so he does come back to court when he needs to, including earlier this year, Judge. I do have some qualms with the probation violations. They're alleging that he failed to report per a letter sent, but his address on this new complaint is 1234 No Home Street. I don't know how much postage to 123 No Home Street is, Judge, but I don't think Mr. Bishop got a letter there. He does inform me that he has been living with his aunt since he had some sewage issues at his house. His aunt stays downtown, Judge. So he will be staying right around the courthouse, and he has no failures to appear, so I don't believe we're gonna have any issues having him come back. Your Honor, I've talked to Mr. Bishop. He understands that he does need to stay away from the Federal Reserve Bank for now. He needs to stay away from that area just to be safe rather than sorry. He does work sporadically at the stadium when he is able to, Judge, but I think with no failures to appear, a stay away order would be appropriate, and an OR bond would ensure both the community safety and ensure that he's able to come back because he does.
From the state. Is there anything?
State would just ask for the stay away from the Federal Reserve Bank, for the remainder of the bond.
Mr. Bishop has 2 felonies, 12 misdemeanors, with 0 prior failures to appear. It'll be OR plus stay away from the Federal Reserve. It appears that the trespass from the here is that he was previously warned not to trespass on federal property, but not, that would assume Mr. Bishop knows every piece of federal property in downtown. But the court, if counsel or someone from your division could just direct the defendant to places that he should stay away from.
Yes,
to avoid him from being arrested. That's all.
Yes.
It'll be an OR bond. All right. Thank you, sir. Yeah, that's what I was about to do. Tasia Brown, Christoph Gardenhire, Prince Israel, Ms. Brown, come on up. Good morning, ma'am. All right, is there anything from the state?
No, Judge.
All right. It will be the same OR bond. You will go get a new court date, all right? In room 117, all right? You just go out that door. Thank you, ma'am. Gardenhire, good morning, sir. All right. What number OVI is this?
This is the first,
First in lifetime, but
yeah,
there is one pending.
it is, yeah, it's the first
All right.
lifetime that there is a pending.
And is it a refusal or a test?
It's a refusal. He was then taken to UC's hospital for a blood test that is pending.
There's no accident. Insurance is marked yes, but the state is gonna request a public safety suspension.
You said no accident?
No accident.
I do believe the other case is pending in front of Judge Dwayne Mallory at this moment.
All right. Mr. Gardenhire, did you pay the bond to get out?
Yes.
All right, so it'll be the same bond that you already paid, which was $1,000 anyway. There is a public safety suspension in place, so you are not to be driving until you get appropriate privileges from Judge Mallory's courtroom. All right? You'll go to room 117. Yes, sir. This is a different charge. Yes, sir. All right? 117.
And no alcohol.
Hold on. No alcohol is a condition of bond as well. All right, Mr. Gardner. Thank you. All right, Prince Israel. Good morning, Mr. Israel. All right. Did you pay the bond on this? All right. Anything, what is number OVI is this?
From what we have at this point in time, it does appear to be a first. There was no accident. Insurance is marked no on all 3 tickets. The ALS is in place. There was a refusal, and there's also the obstruction of the possession of the open container. The court needs more information on that.
All right. I don't unless the state has a different position on the bond that Mr. Israel has already paid.
No.
All right, it'll be the same bond you paid, Mr. Israel. There is on the OVI and ALS in place, so you are not permitted to drive until Judge Harris will give you privileges, okay? All right, you'll go to Rule 117, sir. Thank you.
Alcohol is a condition of bond.
This is, first, the court is not gonna order no alcohol altogether. All right, Boynton.
That'll complete the county docket. Thank you.
Thank you.
Boynton.
Your Honor, we're gonna enter a not guilty plea, and I have a lot that I could say for Mr. Boynton, but
You don't need to. Is there anything from the city? There's no record as an adult or juvenile, no failures to appear as an M4 disorderly conduct.
We'll defer this bond.
OR.
although, Your Honor, I do just have one question, because in looking at the complaint, I just like to request a little clarity from the state. It seems like this is charged as the in 4th degree. There is no such charge, Your Honor.
That's misdemeanor, I think, there's 2 M's in misdemeanor.
Oh, misdemeanor. Okay, fair enough.
That's-
4th degree is what they're looking for. Very good. Okay, you're good.
OR.
We want to really make it clear it's a misdemeanor, not a felony, that
Boyle.
Or Boyle. 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 Boyle, this way.
You're right up here with me, Mr. Boyle. And Your Honor, at this point, we're gonna be entering a not guilty plea, though I believe Mr. Shanling and or Judge Bender has.
Made very specific notes for me to follow.
Yes.
It will be the same bond.
And, could we, I don't know, if this came first to be signed, Commissioner, in this email from Mr. Shanling, it had indicated that.
Supposed to be Monday.
Yes, I just wanted to make sure that that was on for Monday.
It does not have it on the judge's sheet, but I do know it is supposed to be set for.
Sometimes they get me flagged out next day settings.
Yeah. Continue to room 174. What is Monday?
6:17.
Thank you. 8:17 at 9 a.m.
Yes, Judge.
All right, thank you. All right, Harper.
Harper. Come on out, Mr. Harper. Straight out.
Judge, it'll be not guilty, Mr. Harper.
Good morning, Mr. All right, Esteban.
There's Esteban, I do know there's a holder component in this court, but I will be asking Your Honor to consider it a law bond. The holder out of conduct police court is a felony with 5th degree, simple possession charges, have been eligible for drug court previously with Judge Sanders. Judge, I believe the goal there is going to be getting Mr. Harper involved, if you would like to be, get hooked up with treatment. To avoid any delays, I have had that problem with Judge Sanders getting misdemeanors and felonies linked up. We would ask Your Honor to consider an OR. The prosecuting witness, For context, Mr. Harper had been a house manager over at Miracle House. He'd been there for about 6 years and worked his way up that responsibility. Prosecuting witness was somebody else that had been presiding there. It is my understanding that neither person is residing at Miracle House going forward, Judge. Mr. Harper did suffer a concussion pretty recently. I do have some concerns about obviously getting that treated here at the Justice Center. Their medical staff is great with the resources that they have. However, they are limited in what resources they're able to access, Judge. We would ask for OR, SOR.
From the city.
From the city, we do have some concerns based on the allegations that the defendant struck the victim with a shovel in the left arm and leg, causing physical injury. State like a Monte bond is appropriate in this case.
There's 1 violent felony, 7 felonies, 5 violent misdemeanors, 10 misdemeanors, 5 prior failures to appear. The assault will be $2,500 anyway, plus juris if requested. The M4 drug paraphernalia will be an OR bond. Harris.
Judge, I will to leave Mr. Harris. He is not feeling well, from my understanding of the statement of corrections, but officers are back. I would have to send him over for Monday so that we can get an attorney. I'm not able to speak to him.
We will continue to 817 room A at 9 a.m.
Thank you, Judge.
I'll keep whatever the standard bond right now is $2,500, so that'll be the bond. All right, my hand. Gary's my hand.
My hand. Mr. Ryan is very interested in resolving these cases with Mr. Yang.
Yeah, which one do you want?
Judge, we could plead to the pedestrian violation, dismiss the 2020 or the 2013 charge.
That's fine with the state.
Good morning, sir. Mr. Myhand, a guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties. Do you want to maintain a guilty plea to a pedestrian violation?
Yes, okay.
Counselor, do you waive and stipulate?
Absolutely.
Finding of guilty, Mr. Myhand has been for 1 day.
Yes, Judge.
Is there anything else?
Judge, yes, he does work at Jimmy John's. He's in his uniform. We would ask for credit for the night.
Anything from the city?
Nothing from the city.
1, credit 1, remit the fines and costs. 13 cases dismissed for plea.
Thank you, Judge.
Thank you. Christopher Newman.
Okay.
Straight back across.
And I don't know if Mr. Yang
Newman.
is trying to drop this to a minor and change her plea. He has absolutely no record whatsoever.
That should be fine.
Newman. Straight out to the officer.
And Judge, I believe we do have a plea agreement worked out with the city to reduce this charge to a minor misdemeanor.
That's correct.
All right, Mr. Newman, a guilty plea is a complete admission of guilt. The amendment takes this from a misdemeanor of the 4th degree to a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties. Do you want to maintain a guilty plea to a minor misdemeanor disorderly conduct?
Yeah.
Counselor, do you waive and stipulate?
Absolutely, Judge.
That includes waiver of service of a new complaint and arraignment.
Absolutely.
Finding of guilty. 1 night.
Yes, Judge.
Is there anything from the state?
Nothing from the state.
1, credit 1, remit the fines and costs, control your alcohol intake, Mr. Newman.
Absolutely, Judge. Thank you.
Naya Kundi.
Straight back across. Nice, Andy. Straight out to the officer.
And Judge, if we not guilty, we have to met Ryan Kennedy.
Good morning. Anything from the state?
Ask people to stay away from Hard Rock Casino.
And Judge, we would just note regarding the sale, Mr. Nyakundi's car is currently parked at the casino. We would ask for limited permission to go either with an escort, security, or police to retrieve his vehicle from that facility.
They would not object so long as there's some escort and that he's on stage and previous calls.
What was,
Judge, just another thing that I completely forgot to mention, Mr. Nyakundi's wallet is being held by the casino. We would ask again for limited purpose in entering the casino solely to retrieve his property. We are more than happy to do that either with Hard Rock security or with a sheriff's officer that would be available.
We have a sheriff's detail that works.
to get ID. It'll be an OR bond plus a stay away from Hard Rock. I put on here that defendant may go directly to the parking, directly to casino and parking garage to get his wallet and his vehicle with a sheriff deputy escort.
Thank you, Judge.
All right. Patterson.
Patterson.
This is Ms. Patterson. I'll let her plead not guilty.
I will tell you I'm not inclined to modify the bond that Judge Mallory set. The reason being is this is Judge Mallory's case, and the notes on the bond are that yesterday the magistrate checked with the judge who the case is assigned to and specifically asked about the bond, and the judge that it is assigned to said that was the bond that the judge apparently wanted. So I am not inclined to change the judge's bond who the case is assigned to. But I will allow you to make an argument for the record.
Okay, Your Honor, she is 24 years old, Your Honor. I do see that she has a very, very limited criminal record. I see one misdemeanor on her record. Judge, I do see this is a 2021 case. She has 3 children. She got a 6-month-old daughter that she needs to get home to. She got a 3-year-old daughter as well, and a 2-year-old son. Judge, I have 2 points of contact for her. I have a good phone number and address for her and for her mother as well. She is okay with the EMU if the court's inclined to give her an alternate as well, Judge. She is gainfully employed at Fort Villa, which is verified by pretrial services, full-time. She's supposed to be there at 7 o'clock this morning today, so she's missing that job. She's been unable to reach a supervisor to let the supervisor know that she's unavailable for today. She's very concerned about losing that job because she's sole support for her 3 children.
If you want to put this to the end of the docket, I will try to call Judge Mallory.
Okay, Judge. Can I recall it?
When we get to the end of the docket. We only have a few more cases, and then I'll call him and see. I'm gonna just leave it. All right. Jonathan Sester.
Your Honor, he's been waived. He's sitting unavailable, so I'd like to
For Monday.
set it for Monday.
Continue. Do that one too. All right, Richard White.
Your Honor, I'm also submitting my designation for a case that's outstanding, except for pretrial conference as well.
Good morning, Mr. White. All right.
Yeah, he's here this morning in a series of traffic cases. He apparently had been cited twice on 2 different matters, so used by court dates. He had no intention on missing those court dates, Your Honor. It's important to also note he was not driving when he was arrested for this. He was located or cited on the street and police officers who encountered Mr. White knew that he had outstanding cases, Judge. He has 3 boys, one who lives in Atlanta, who's 20 years old. He's got physical custody this weekend, he's 13 and his 12-year-old. His mother, he tells me his mother, Mr. White's mother, is an employee at River City. She is watching the boys today, but she is missing work today because Mr. White is here in jail. He's 41 years old, lived in Cincinnati his entire life. I have 2 points of contact with him as well. I have his mother's number at River City. I'm engaged with River City as well in different matters, so I know his mother as well. Judge, I believe he has a pending case in 164 that's set for next week. I've designated on that case. Mr. White has indicated that he's going to stay in good contact with me regarding these matters, Judge. Just asking for a reasonable or alternate on these traffic matters, Judge, to allow him to be in court next week on the pending case, Judge. I don't have a 527 on this case, so I'm not really sure about his particular orders.
From the state,
The state will respond.
these are all traffic and they are magistrate set bonds. I will put an OR bond on it. Mr. White, there are 6 failures to appear. The only reason that you spent tonight in jail is because you didn't show up to court. There is literally no other reason. Stay in contact with your attorney, show up. You're sitting in jail really for no reason at this point, and if you don't show up, that's when you're gonna be, again, for no reason, all right? Stay in contact with your attorney so you get all these resolved. Thank you. All right. Villa Alba. Okay. Good morning, ma'am.
Morning.
Did you pay a bond?
Yeah, the cop, when he gave me my original ticket, wrote the wrong court date on there, and he put the 13th and it was apparently on the 11th.
Alright.
So I paid $2,000, I think, yesterday.
On the improper signal or turn, the bond will be OR. That's a first stepper. Is there anything from the state?
Nothing further from the state.
This was a first ever when it was originally cited. It'll be an OR bond on both. You can go to, out there, so that 117, well, I think, does she have to stop there to sign the OR bond? Yeah. Go out the exit door and check with them, okay?
Okay,
Thank you. All right, and then give me 1 second. I'm gonna try and Judge Mallory.
That's okay. Okay. Do you have my card? Oh, so I'll let the judge know that her father is here as well, Mr. Patterson. Mr. Patterson. Her father is here.
Absolutely not. And they went down that small horrible. Don't do that.
We can recall Ms. Patterson.
Please. Your Honor, Ms. Patterson's father is here and would like to speak. Briefly on her behalf.
Yes, are you able to pay any type of bond, 1,000 at 10% on each? All right, it'll be like $200 and some dollars.
$254.
All right, I talked to Judge Mallory, explained what was going on. He was okay with the bond being changed to 1,000 at 10 on both cases. All right? All right, ma'am, make sure you show up. That was gracious of Judge Mallory today, and a lot of judges will not walk off the bench to call another judge on a Saturday. So make sure that you show up, all right? All right, thank you. That's the docket, thank you.
7 o'clock. That's our time.
Yes, 7, please.